Thank you for visiting the Coin Lady channel again. You guys have been waiting for the wind for a long time, and every day brings new twists and turns to the situation as the ongoing legal battle between SEC and Ripple intensifies with new allegations. It's impossible to make predictions about what will happen in this case. Conversely, you finish up on the receiving end of the Securities and Exchange Commission's (CIS) dishonest and unfair practices. Do it all, despite Ripple's claims that the SEC is trying to regulate cryptocurrency too much with vague laws. Recently, Ripple's chief legal officer Doherty expressed his displeasure with the SEC's handling of the XRP matter. He has shed light on the larger issues facing the cryptocurrency sector and what he perceives as unfair methods. Innovation should not be seen as a partisan issue. Following their long-running dispute with the SEC, it is encouraging to see that the Democrats and Republicans have been able to come to an agreement on one topic. During the trial, Aldrich accused the regulator of unlawful acts and found some interesting parallels between the SEC's behavior and the absurdities in Franz Kafka's work. The legal strategy employed by Ripple involves requesting the sealing of important financial documents in anticipation of their public release. Ripple believes that the approach taken by the SEC is unfair and lacks transparency, reflecting larger issues that other cryptocurrency companies like Coinbase and Robinhood are facing. To safeguard its interests, Ripple has taken certain actions. The relevant records include crucial details on income, expenditures, and discounts given to institutional investors, in addition to earnings, revenues, and spending. Ripple claims that disclosing such information would jeopardize user privacy and hurt its business interests once they bought XRP. In light of this, the SEC secretary has requested that Ripple pay a $2 billion fine for allegedly selling XRP to institutional investors. But Ripple's legal team argues that CC's demand is unwarranted and that any civil penalty should not exceed $10 million. Additionally, they claim that since there is little customer loss and more worries about rules, Ripple should not be forced to pay this large amount through unlawful means. Issues with regulation enforcement and company operations are brought to light by Alderty's criticisms of the Bitcoin industry. To make matters worse, the SEC has given Ripple and other cryptocurrency firms what it calls inconsistent input, making it harder for them to meet their regulatory requirements. A legislative response to the ripple effects of the U.S. government's legal battle over the second season's regulatory authority emerged in an effort to rein in the Securities and Exchange Commission. The House of Representatives has already set aside time for Commission SEC to work together on cryptocurrency legislation. In particular, a recent vote in the House of Representatives repealed the SEC staff accounting. Financial institutions are obligated to disclose their customers' cryptocurrency holdings on their balance sheets, per this advisory. Implications for the Bitcoin market as a whole in light of the SEC case. For all things related to cryptocurrencies, SEC is a big deal. Keep in mind that the SEC has also cast doubt on Ripple's future stable coins, leading to greater transparency. The outcome may set new standards for the regulation of digital assets. Lastly, Eldorado's claims against the SEC are clear and significant. The victory of the SEC would hurt the cryptocurrency market because other assets will be burned while they wait for similar verdicts due to XRP's categorized position as a security. In the ongoing legal battle between Ripple and the U.S. Securities and Exchange Commission, Ripple's chief legal officer, Doherty, has likened the SEC's actions to the blunders depicted in the novel by Francis Doherty, Through the Trial. I understand. The fact that Doherty has been critical of the SEC throughout the investigation and the Wells notice process for what he sees as unfair treatment of XRP versus SEC implies that the issue is more systemic and impacts other cryptocurrency firms like Coinbase and Robinhood. The contradictory measures done by the SEC are criticized by various Ripple. Throughout the continuing proceedings, Ripple has maintained its position that the SEC's handling of the case has been marked by injustice and inconsistency. Kafka claims that Ripple's chief legal officer's work is a scathing indictment of the regulators, what Ripple views as arbitrary and opaque actions. Ripple sees this as emblematic of the larger problems that cryptocurrency companies face, as the SEC often gives them inconsistent opinions. The SEC is requesting over $2 bail from Ripple for selling XRP to institutional investors, and other companies like Robinhood and Coinbase have also reported similar regulatory hurdles. Ripple is still facing significant penalties from the SEC. When asked about the potential harm to its commercial interests, Ripple filed and sealed documents that highlighted the disclosure of financial details. Ripple has asked for the removal of some personally identifiable information, PII, including details about its financial performance, profit, revenue, expenses, and XRP sales discounts to institutions. Despite acknowledging the significance of these reductions, Ripple is hesitant to disclose the particular financial conditions due to the necessity to retain business secrets. This is despite the fact that Ripple is opposed to the SEC's excessive regulation of Bitcoin. The company's employees, customers, and non-party financial institutions will all have their identities shielded by Ripple's decision to use seal papers. The corporation maintains that revealing this information could jeopardize valid privacy concerns and hurt collaborations. According to XRP, these kinds of disclosures would hinder the company's ability to operate efficiently in the market and would also affect its partners. No civil penalty should exceed $10 million, XRP says again, in spite of the SEC's hefty requests. This stance is reflective of Ripple's belief that the SEC's pursuit of $2 billion is overly harsh and misrepresents the larger problems that arise in the cryptocurrency industry when regulations are enforced and companies operate. The SEC's broader regulatory stance in the U.S. House of Representatives has been highlighted by the XRP court action. Stewart Alder Rhodey has praised bipartisan attempts to limit the SEC's overly expansive Bitcoin regulation. A recent vote in the House of Representatives successfully repealed the Securities and Exchange Commission's Staff Accounting Bulletin No. 121 AB 121. According to this provision, banks are required to disclose their clients' cryptocurrency assets on their balance sheets. Regarding Ripple Labs, since Ripple's chose to keep some papers from the public, the legal dispute has ramped up. The video concludes with that. It would mean the world to me if you could subscribe to my channel and like it. Goodbye, see you later.